Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, mm-hmm. but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
but
Senator.
That's not what you just said.
Ladies and gentlemen, patriots across this great nation, welcome back to Founding Voice America, where the Constitution still matters, where we speak boldly, and where the truth doesn't need a permission slip. Now let me tell you something. You need to buckle up for this one. Because what we're about to break down is not just a routine Senate hearing. Oh no. It's a masterclass in exposing the complete breakdown of constitutional understanding in today's judicial nominees. Senator John Kennedy, God bless that man, is out here doing what more of our Republican senators ought to be doing. Putting these judges on blast and forcing them to explain basic constitutional principles that every high school civics student should know. And let me be clear, this isn't just some gotcha moment. This is deadly serious. Because the people sitting in front of Senator Kennedy, they're not just lawyers. They're nominees to serve as federal judges, potential lifetime appointees to the bench. And what we see in this hearing should absolutely terrify any American who gives a damn about the rule of law, state sovereignty, and actual justice. Senator Kennedy opens up with a basic question: what's the warrant requirement? Now if you're a judge, this is elementary. It's day one stuff. You'd expect a crisp, clear, confident answer. But instead, what do we get? Stammering. Uncertainty. A painfully awkward back and forth that reveals just how shallow the constitutional understanding runs in these nominees. The answer, for those of you at home: the Fourth Amendment requires a warrant before the government can go rummaging through your home, your car, your phone, or your person, unless a clearly established exception applies. That's not debatable. That's settled. That's America. And Kennedy, he's not playing softball. He dives in. He asks, what if the Florida Supreme Court decides there will be no exceptions? You must have a warrant, no matter what? Now pause and think. That's a real question about state power, about whether a state can grant more rights to its people than the federal government does. And what does the judge say? She fumbles. She invokes the Supremacy Clause, as if it overrides everything. Wrong. Let me break it down for the folks in the back. The Supremacy Clause means federal law trumps conflicting state law. But here's the thing: if a state gives its people more rights, not fewer, that doesn't conflict with the Constitution. That enhances it. It's called adequate and independent state grounds. It's been reaffirmed over and over again. But this judge, she didn't know. Or worse, she did, and still got it wrong.
Kennedy, to kick us off.
Thank you, Madam Chair. Judge Dudick, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required any time that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required any time the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution
No,
said
they wouldn't.
Under the Supremacy
Do
Clause.
you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
That's
Senator.
not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
You want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize, I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say this group, we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
Tell
could
me first if a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example,
When can a state?
Now this isn't just about legal trivia, folks. This is about protecting our constitutional republic from activist judges who don't understand, or worse, don't respect, the sacred balance of federalism our founders set up. These judges are supposed to defend the Constitution, not butcher it, not water it down, and not misinterpret it so they can ram through whatever ideology they carry in their briefcase. Let's not sugarcoat it. This is what happens when we let the left control the legal education system for decades. We've got an entire generation of lawyers and judges who treat the Constitution like it's some outdated relic instead of what it really is, the supreme law of the land, divinely inspired and fiercely protected by the blood of patriots. Senator Kennedy schools this nominee on basic federalism, and she has to walk back her answer mid-hearing. That's how little confidence she had in her understanding of the Supremacy Clause. Embarrassing. Absolutely embarrassing. Then comes Judge Pratt. And Kennedy ain't done. He poses another basic but essential question. Can a state legislature pass a law that discriminates against one group of people over another? Now we all know the answer to that. Hell no. Not unless it passes strict scrutiny and complies with both the state and federal constitutions. So what does Judge Pratt say? She dodges. She brings up driving ages. As if setting a driving age is the same as discriminating based on race, religion, or viewpoint. Give me a break. This is the problem with the modern leftist legal mindset. They treat every question like it's a debate club exercise instead of a matter of principle. The Constitution wasn't written to be interpreted creatively. It was written to be followed. And when judges can't even say whether the government can treat some citizens worse than others, we're in serious trouble. Look, patriots, I don't want judges who need to be spoon-fed the Constitution by Senator Kennedy. I want judges who come into that hearing room with the Federalist Papers burned into their brains. I want judges who don't just read the Constitution. I want them to revere it. I want judges who don't apologize for enforcing law and order. I want judges who understand that state sovereignty is not optional, it's foundational. Because here's the hard truth: if we keep confirming judges like these, who are confused, unprepared, or worse, indoctrinated, then we're handing over our liberties to a permanent ruling class of elites in robes who don't answer to we the people. And that, my friends, is how empires fall. So what do? We watch. We vote. We demand better. Call your senators. Tell them you want constitutional originalists, not progressive activists in black robes. Share this video. Light up the comments. And if you haven't subscribed to Founding Voice America, now's the time. Because this channel is more than a voice, it's a warning. America is worth fighting for. This Constitution is worth defending. And if the judges won't do it, we the people sure as hell will. God bless you. God bless our Constitution. And God bless the United States of America.